Welcome to today's program, Legal Ethics, The Dirty Dozen, Part 2. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Today's program is a legal ethics program focusing on the Dirty Dozen, by which I mean the 12 dirtiest, most unethical lawyers in the history of lawyering in the United States. In Part 1, we covered Bill Larack and Mel Weiss of Milberg Weiss, former Illinois Governor Rod Blagojevich, former Vice Presidential Chief of Staff Scooter Libby, and former President Bill Clinton. Now we're ready to reveal the next 4 lawyers on our list of the 12 most unethical lawyers in United States history. We'll take you through what each of these guys did that got him into hot water, which laws and ethics rules they broke in the process, and give you some insight into how these guys went from legal eagles to legal turkeys. In what probably comes as no surprise to many of you, the last 4 names on our list are all criminal defense lawyers, including our number 1 most unethical lawyer, who turned out to be a plain old criminal who just happened to be a lawyer. Former Attorney General Alberto Gonzales is number 7 on our list of the 12 most unethical lawyers in U.S. history. Gonzales served as Attorney General of the United States under President Clinton's successor, President George W. Bush. Although Gonzales resigned as Attorney General just as the House Judiciary Committee was preparing to open an impeachment investigation against him, based on charges that he lied to Congress about his involvement in the controversial firing of 7 U.S. attorneys. Gonzales was never charged with a crime or violation of the legal ethics rules, and to this day he still has a law license, although he does not practice as he currently serves as the Dean of Belmont Law School in Nashville. It might seem unfair to put Gonzales on this list alongside the other lawyers who, in most cases, were convicted of felonies and disbarred as a result of those convictions. Yet, I believe that Alberto Gonzales deserves it for 3 things he did while in office that, taken together, not only compromise the independence and integrity of the office of the Attorney General of the United States, but that also made America less safe to this day because of actions our government took on his watch while fighting the war on terror. To be specific, Gonzales used his positions as White House counsel and Attorney General to authorize the CIA to use enhanced interrogation techniques, aka torture, on suspected terrorists, and to authorize the NSA to eavesdrop on U.S. citizens without warrants, where the NSA believed the citizen was speaking with a suspected terrorist. In addition, Gonzales orchestrated the firing of 7 U.S. attorneys for political reasons, and then lied in his testimony before Congress about the firings. It is a shame how Alberto Gonzales ended his legal and political career, resigning the post of Attorney General in disgrace and to avoid impeachment proceedings, particularly given the inspiring life he had led up to that point. Gonzales was the son of Mexican immigrant farm workers, one of 8 children, and the family lived in a 3-room home with no telephone and no running hot water. He was raised in Humble, Texas, which gives Bill Clinton, who was born in Hope, Arkansas, a run for his money in terms of the best origin story. On his way up, Gonzales achieved several impressive firsts. After graduating from Rice and the Harvard Law School and working for many years as a lawyer, he was the first Hispanic partner ever made at the prestigious Texas law firm of Vinson & Elkins. Gonzales then served as general counsel to then Governor George W. Bush and Texas Secretary of State before he was elected to the Texas Supreme Court in November 2000. By any measure, Gonzales had done very well for himself, having started out as a poor kid from Humble, Texas, even before he made the move to Washington, D.C. Before leaving Texas, there is an interesting story from Gonzales' time as the general counsel of Texas that is indicative of what would come next in terms of his long-standing relationship with George W. Bush and his lack of independence when acting as his lawyer. While he was governor of Texas, George W. Bush was called for jury duty in a 1996 drunk driving case in Travis County. In any case, on Gonzales' advice, Governor Bush submitted his jury questionnaire and declared that he was ready and willing to serve on the jury. One problem: on that jury questionnaire, Mr. Bush failed to disclose his own 1976 misdemeanor drunk driving conviction. While we can never know the true facts, it is reasonable to assume that Gonzales advised Mr. Bush not to disclose his prior conviction to avoid having come out in the press and renew a focus on Mr. Bush's reckless youth? Do you remember the clever phrase Mr. Bush used during the 2000 presidential election whenever a reporter asked him about his past use of alcohol and drugs? Quote, "When I was young and irresponsible, I was young and irresponsible," end quote. In another odd twist in the drunk driving jury case, Gonzalez actually raised the possibility to the court that Mr. Bush could have a conflict of interest in serving on the jury because as governor, he might be called on to pardon the accused in the case. What? How many times did drunk drivers apply for or receive gubernatorial pardons? This argument seems nuts, but maybe Gonzalez finally realized that having Governor Bush on a jury asked to find a man guilty of drunk driving could not have been a good thing for the governor, no matter how the jury voted. Incredibly, the defendant's lawyer bought into the conflict of interest argument, and he asked the judge to strike Mr. Bush from the jury panel. On that basis, which the judge did. The point of this story is to show that even back then, Gonzalez was not giving Mr. Bush accurate or independent legal advice, i.e., that a jury questionnaire completed under oath needs to be truthful, and that his close relationship and desire to please him at all costs caused him to compromise his legal ethics. Unfortunately, Gonzalez's time in Washington gave him ample opportunity to continue to serve as President Bush's yes man rather than as the nation's top lawyer, to disastrous effect for the DOJ and the United States of America. Let's start with the offense that put him on track to potential impeachment, even though it arguably was the least bad thing Gonzalez did when compared to authorizing far worse conduct on the part of the CIA and the NSA during the War on Terror. As we know, United States attorneys are appointed to 4-year terms, but they serve at the pleasure of the president and can be removed by the president at any time for any reason or no reason, as long as it is not for an illegal or improper reason. While a president can remove a U.S. attorney during his or her term, traditionally the top federal prosecutor in each district is considered an apolitical appointee who is entrusted to uphold and enforce federal law fairly and impartially and without political motive or interference from the president or the DOJ in Washington, led by the Attorney General. Soon after Gonzalez was appointed Attorney General in February 2005, he ordered a performance review of all U.S. attorneys. On December 6, 2007, 7 U.S. attorneys were informed by the DOJ that they were being dismissed. Although the true motives for each of the 7 firings are unknown, critics suspected that these U.S. attorneys were fired in order to replace them with lawyers who were more loyal to President Bush or as retribution for actions they took that were damaging to the Republican Party. In essence, 7 U.S. attorneys were fired for political reasons in contravention of the long-standing tradition that these federal prosecutors serve in an apolitical capacity. When asked about the firings during a press conference, Gonzalez claimed that his knowledge of the process to fire and select U.S. attorneys was limited to how the U.S. attorneys may have been classified as strong performers, not as strong performers, and weak performers, and that he was not involved in seeing any memos, was not involved in any discussions about what was going on. That's basically what I knew as the Attorney General.
Let me begin with some core principles, some things that I believe in. One, I believe in the independence of our U.S. attorneys. They are the face of the department. They are my representative in the community. I acknowledge their sacrifice. I acknowledge their courage to step into the arena on behalf of the American people. Secondly, the Attorney General, all political appointees, such as U.S. attorneys, serve at the pleasure of the President of the United States. Third, I believe fundamentally in the constitutional role of the Senate in advice and consent with respect to U.S. attorneys, and would in no way support an effort to circumvent that constitutional role. I believe in accountability. Like every CEO of a major organization, I am responsible for what happens at the Department of Justice. I acknowledge that mistakes were made here. I accept that responsibility, and my pledge to the American people is to find out what went wrong here, to assess accountability, and to make improvements so that the mistakes that occurred in this instance do not occur again in the future. Finally, let me just say one thing. I've overcome a lot of obstacles in my life to become Attorney General. I am here not because I give up. I am here because I've learned from my mistakes, because I accept responsibility, and because I'm committed to doing my job. And that is what I intend to do here on behalf of the American people. With that, I'll take your questions.
Mr. Attorney General, can you explain what the White House role is, specifically when your successor, Harriet Mier, suggested that perhaps all U.S. attorneys should be changed over? Is that the seed that started all of this? How does that connect to the actual termination late last year?
As we can all imagine, in an organization of 110,000 people, I am not aware of every bit of information that passes through the halls of the Department of Justice, nor am I aware of all decisions. As a general matter, some 2 years ago, I was made aware that there was a request from the White House as to the possibility of replacing all the United States attorneys. That was immediately rejected by me. I felt that that was a bad idea, and it was disruptive.
Is that the end of it then?
What I know is that there began a process of evaluating strong performers, not as strong performers, and weak performers. And so as far as I knew, my chief of staff was involved in the process of determining who were the weak performers, where were the districts around the country where we could do better for the people in that district. And that's what I knew. But again, with respect to this whole process, like every CEO, I am ultimately accountable and responsible for what happens within the department. But that is, in essence, what I knew about the process. Was not involved in seeing any memos, was not involved in any discussions about what was going on. That's basically what I knew as the Attorney General.
Once Congress started to investigate the firings, it became clear that Gonzalez had lied at his press conference. For example, the DOJ released records showing that Gonzalez attended an hour-long meeting at which aides said he approved a detailed plan for executing the purge. Despite claiming he had not been involved in the decisions, DOJ emails released later suggested that Gonzalez indeed had been notified and that he had given final approval for the firings, as one would expect the Attorney General to do if such a drastic and unusual step of firing 7 U.S. attorneys in the middle of their terms were to be taken. So, Gonzalez lied to the press when asked about the firings. Is that a crime or ethical violation? Probably not, otherwise every lawyer who is a politician would be on his or her way to jail and a state bar hearing. But Gonzalez took it a step further when he testified under oath before Congress and repeated some of those same falsehoods, including denying that he was involved in the firing decisions. Yet, additional DOJ documents prove that in the case of at least one of the fired U.S. attorneys, Carol Lamb, Gonzalez urged her ouster 6 months before she was fired. During his congressional testimony on April 19, 2007, Gonzalez also stated at least 71 times that he did not recall events related to the controversy, even though the firings happened less than 6 months earlier. As we learned from President Clinton, perjury is both a crime and a violation of Model Rule 8.4d. Now, you might be tempted to say, hold on a minute, Gonzalez wasn't convicted of perjury or found guilty of any ethical violations. In fact, an investigation by the Inspector General of the United States found no evidence that Gonzalez made false or misleading statements to Congress. I think you can fairly question the result of an investigation led by the Inspector General appointed by President Bush failed to find evidence of wrongdoing by the Attorney General appointed by President Bush, who also happened to be a longstanding friend of President Bush. As noted, Gonzalez resigned before Congress could open its own impeachment investigation, and after repeated calls for appointment of an independent counsel to investigate Gonzalez were rejected by the Bush White House. If you had put the Democratic equivalent of Ken Starr on the Gonzalez case, I suspect that he or she would have found evidence of perjury and other official misconduct in connection with Gonzalez's firing of the 7 U.S. attorneys. Gonzalez should have known better than to allow President Bush to pursue a political agenda at the expense of the law and his duty as Attorney General to follow it. Unfortunately, this was the least of his many sins while holding this important office. Gonzalez's worst sin was writing legal memos and opinions that the CIA and others relied upon as their legal authority to torture suspected terrorists. Not only is torture contrary to U.S. and international law, i.e. the Geneva Convention on the Treatment of Prisoners of War, the revelation that the U.S. engaged in torture not only undermined our moral authority and standing in the world, but has served as a recruiting tool for Al-Qaeda, Taliban, ISIS, and other radical elements who seek to kill Americans to this day. Specifically, while serving as President Bush's White House counsel, Gonzalez authored a legal memo in which he referred to as quaint certain provisions of the Geneva Convention that Gonzalez argued were ill-suited for dealing with captured Al-Qaeda and Taliban fighters. While Gonzalez had a point about the requirement to give prisoners of war commissary privileges, scrip, athletic uniforms, and scientific instruments, he missed the main point entirely, which is that torture is never okay, even for suspected terrorists. Gonzalez came up with a clever euphemism for torture, enhanced interrogation techniques, to make it sound like something else, but there can be no doubt that what we were doing is torture here, as the techniques included, among other things, facial slaps, sleep deprivation, stress positions, insects placed in a confinement box, and waterboarding. It is shameful what was done to other human beings by agents of the United States, and to make it worse, under the color of law as sanctioned by the Attorney General of the United States. Before Gonzalez came along, these forms of torture always had been understood to be illegal under U.S. law, including the War Crimes Act of 1996, as well as under the Geneva Convention, the United Nations Convention Against Torture, and the European Convention on Human Rights. Indeed, the United States government had prosecuted Japanese military officials after World War II and American soldiers after Vietnam for war crimes for waterboarding. In May 2005, the DOJ under Gonzalez issued a legal opinion in which it provided the CIA with explicit authorization to use these enhanced interrogation techniques on suspected terrorists. Not only was this legal opinion dead wrong on the law, it was purposefully misleading in that it purported to follow an earlier legal opinion issued by the DOJ in December 2004, even though that prior legal opinion specifically condemned as torture the acts that Gonzalez's memo now was authorizing. Current FBI Director James Comey, who at the time was a Deputy Attorney General, told colleagues that they would all be ashamed when the world eventually learned of Gonzalez's memo. In 2009, the Obama administration publicly reaffirmed that the United States would abide by the Geneva Convention and described some of the enhanced interrogation techniques authorized by Gonzalez as torture. Unfortunately, by that time, much of the damage to our nation already had been done. Gonzalez's second deadly sin was to authorize the NSA to listen to conversations of U.S. citizens without first having to obtain a warrant if those conversations were with suspected terrorists located abroad. After the New York Times broke the story in December 2005, Gonzalez was forced to reveal publicly that shortly after the September 11th attacks, President Bush had authorized the NSA to monitor these conversations via a presidential authorization prepared by Gonzalez, who was then White House counsel. Under this broad grant of authority, specific NSA surveillance programs were approved on a regular basis by President Bush, White House counsel Gonzalez, and then Attorney General John Ashcroft. This led to a now famous showdown between Gonzalez, Chief of Staff Andrew Card, and Acting Attorney General James Comey. In March 2004, John Ashcroft was in the hospital recovering from surgery, and James Comey was serving as Acting Attorney General. When Comey refused to authorize an NSA surveillance program requested by President Bush because he concluded it was illegal, Gonzalez and Card sought to bypass Comey and obtain the approval of Ashcroft from his hospital bed. When Comey learned that what Gonzalez and Card were up to, he rushed to the hospital and described the scene as follows. Quote, "In walked Mr. Gonzalez carrying an envelope and Mr. Card. They came over and stood by the bed. They greeted the Attorney General very briefly, and then Mr. Gonzalez began to discuss why they were there, to seek his approval. I was very upset. I was angry. I thought I had just witnessed an effort to take advantage of a very sick man who did not have the powers of the Attorney General because they had been transferred to me." End quote. Another DOJ official who was in the room that night vividly described what happened next. Quote, "Ashcroft, who looked like he was near death, sort of puffed up his chest, and all of a sudden energy and color came into his face, and he said that he didn't appreciate them coming to visit him under those circumstances, that he had concerns about the matter they were asking about, and that, in any event, he wasn't the Attorney General at the moment, Jim Comey was. He actually gave a 2-minute speech, and I was sure at the end of it he was going to die. It was the most amazing scene I'd ever witnessed." End quote. As with the firing of the 7 U.S. attorneys, Gonzalez subsequently gave false testimony before Congress about the Ashcroft incident, after which 4 senators called for an independent counsel to be appointed to determine whether Attorney General Gonzalez may have misled Congress or perjured himself in testimony before Congress. Once again, no independent counsel was appointed, and a subsequent report by the Inspector General cleared Gonzalez of wrongdoing. In criticizing Gonzalez, I don't mean to minimize the difficulty of the job he faced as White House counsel and Attorney General in the years immediately following the September 11th attacks. I lived in New York during 9/11, and I recall vividly the terror that event caused our nation and how the fear of more attacks colored almost every aspect of our daily lives. As Gonzalez himself put it, quote, "The thought I had at the time was, here we go. This is why I became a lawyer. All my work in private practice and on the bench, all of it was for this moment, to advise the wartime president," end quote. The fact is that Gonzalez failed in this great test. What the country needed at the time was an Archibald Cox, the Attorney General who famously stood up to President Nixon when he asked Cox to break the law, and not an Alberto Gonzalez who went along with whatever President Bush wanted to do, whether it was against the law or not. I'm certainly not saying I would have done a better job, but I'm saying that the extraordinary events of 9/11 required an extraordinary response from the men and women of our government, and Gonzalez was not the extraordinary person we needed in that moment. His actions helped America go down a path that was inconsistent with our history and ideals, and has caused all of us to be less safe in a dangerous world that still struggles with radical groups who seek to do us harm. I don't think there's much room for debate that Gonzalez's failure to follow the laws of the United States that he swore to uphold and his false testimony before Congress where he tried to cover up his misconduct were most likely crimes and at a minimum ethics violations. I also believe he violated his ethical obligation to give his client, which as Attorney General is the United States of America and not just the current president, independent advice about what is and is not legal, and to avoid conflicts of interest, such as his friendship with President Bush, that would impair his judgment.
3 months ago, when Attorney General Gonzalez last appeared before this committee, I said that the Department of Justice was experiencing a crisis of leadership perhaps unrivaled during its history. Unfortunately, the crisis has not abated. Until there is independence and transparency and accountability, the crises will continue. The Attorney General has lost the confidence of the Congress and the American people. But through oversight, we hope to restore balance and accountability to the executive branch. The Department of Justice must be restored to being worthy of its name. It should not be reduced to another political arm of the White House. It was never intended to be that. Trust and confidence in the American people and federal law enforcement must be restored. With the department shrouded in scandal, the Deputy Attorney General has announced his resignation. The nominee to become Associate Attorney General requested that his nomination be withdrawn rather than testify under oath at a confirmation hearing. The Attorney General's Chief of Staff, the Deputy Attorney General's Chief of Staff, the Department's White House liaison, and the White House political director have all resigned, as have others. I would joke that the last one out the door should turn out the lights, but the Department of Justice is too important for that. We need to shine more light there, not less. Investigation into the firing for partisan purposes of the United States attorneys who have been appointed by this president, along with an ever-growing series of controversies and scandals, have revealed an administration driven by a vision of an all-powerful executive over our constitutional system of checks and balances, one that values loyalty over judgment, secrecy over openness, and ideology over competence. The accumulated and essentially uncontroverted evidence is that political considerations factored into the unprecedented firing of at least 9 United States attorneys last year. Testimony and documents showed that the list was compiled based on input from the highest political ranks in the White House, that senior officials were apparently focused on the political impact of federal prosecutions and whether federal prosecutors were doing enough to bring partisan voter fraud and corruption cases, and that the reasons given for these firings were contrived as part of a cover-up. What the White House stonewalling is preventing is conclusive evidence for who made the decision to fire these federal prosecutors. We know from the testimony that it was not the president. Everyone who has testified has said that he was not involved. None of the senior officials at the Department of Justice could testify how people were added to the list, or that the real reasons that people were included among the federal prosecutors to be replaced. Indeed, the evidence we've been able to collect points to Karl Rove and the political operatives at the White House. The stonewalling by the White House raises the question, what is it that the White House is so desperate to hide? The White House has asserted blanket claims of executive privilege despite officials' contentions that the president was not involved. They refused to provide a factual basis for their blanket claims, have instructed former White House officials not to testify about what they know, and then instructed Harriet Miers to refuse even to appear as required by a House Judiciary Committee subpoena. Now, anonymous officials are claiming that the statutory mechanism to test White House assertions of executive privilege no longer govern. In essence, the White House asserts that its claim of privilege is the final word, that Congress may not review it, and of course that no court dare review it. Here again, this White House claims to be above the law. My oath, unlike those who have apparently sworn their allegiance to the President, is to the United States Constitution. I believe in checks and balances and in the rule of law. And despite the stonewalling and obstruction, we've learned that Todd Graves, U.S. Attorney in the Western District of Missouri, was fired after he expressed reservations about a lawsuit that would have stripped many African-American voters from the rolls in Missouri. When the Attorney General replaced Mr. Graves with Bradley Schlossman, the person pushing the lawsuit, that case was filed, but ultimately, of course, was thrown out of court. Once in place in Missouri, though, Mr. Schlossman also brought indictments on the eve of a closely contested election, despite a Justice Department policy, long-standing policy, not to do so. This is what happens when a responsible prosecutor is replaced by one considered a, quote, loyal Bushy for partisan political purposes. Mr. Schlossman also bragged about hiring ideological soulmates. Monica Goodling likewise admitted crossing the line when she used a political litmus test for career prosecutors and immigration judges. And rather than keep federal law enforcement above politics, this administration is more intent on placing its actions above the law. The Attorney General admitted recently in a video for justice employees that injecting politics into the department's hiring is unacceptable. But is he committed to corrective action and routing out the partisanship in federal law enforcement? His lack of independence and tendency to act as if he were the president's lawyer rather than the Attorney General of the United States makes that doubtful. From the infamous torture memo to Mr. Gonzalez's attempt to prevail on a hospitalized Attorney General Ashcroft to certify an illegal eavesdropping program, to the recent opinion seeking to justify Harriet Miers' contemptuous refusal to appear before the House Judiciary Committee, the Justice Department has been reduced to the role of an enabler for this administration. What we need instead is genuine accountability and real independence. We learned earlier this year systematic misuse and abuse of national security letters, a powerful tool for the government to obtain personal information without the approval of a court or prosecutor. The Attorney General said he had no inkling of these or other problems with vastly expanded investigative powers. But now we know otherwise. Recent documents obtained through Freedom of Information Act lawsuits and reported in the Washington Post indicate that the Attorney General was receiving reports in 2005 and 2006 of violations in connection with the Patriot Act and abuses of national security letters. Yet when the Attorney General testified under oath before the Senate Select Committee on Intelligence in April 2005, he said that the track record established over the past 3 years has demonstrated the effectiveness of the safeguards of civil liberties put in place when the act was passed. Earlier this month, in response to written questions I sent to the Attorney General about when he first learned of problems with national security letters, he once again failed to mention these reports of problems. Only with the openness and honesty that brings true accountability will the Department begin to move forward and correct the problems of the last few years. Instead, we have leadership of the Department of Justice who expressions of concern and admissions that mistakes were made only follow public revelations and amounts of regrets, really not that the mistakes and excesses were made, but apparently regrets that somebody found out about those excesses. In the wake of growing reports of abuses of national security letters, the Attorney General announced a new internal program. This supposed self-examination, with no involvement by the courts, no reports to Congress, no other outside check, essentially translates to trust us. But with a history of civil liberty abuses and cover-ups, this administration has squandered our trust. I am not willing to accept a simple statement of, trust us. I don't trust you.
Apart from the efforts to impeach him, which ended when Gonzales resigned in September 2007, you might wonder why no charges were brought against Gonzales for his actions while Attorney General, specifically his authorizations of the illegal CIA torture and NSA surveillance programs. After Gonzales resigned, President Bush appointed Michael B. Mukasey, a highly respected former federal judge and senior DOJ official, as his replacement. I have a special connection to Judge Mukasey in that I clerked for him while he was serving as the district court judge in the Southern District of New York, and I attended his swearing in as Attorney General in September 2007. Judge Mukasey is a conservative, law and order Republican, but he is not a zealot, and above all, he respects and upholds the rule of law. While I have no inside information, I suspect that Judge Mukasey chose not to pursue charges against Gonzales or others because doing so might have exposed men and women in the CIA and NSA who were all doing what they could in the years after 9/11 to prevent another attack, to potential legal liability for their actions, even though they relied on the opinions issued by Gonzales and the DOJ. More broadly, like President Ford's pardon of Richard Nixon, I suspect Judge Mukasey believed that the nation needed to move on from the misdeeds of that early Bush years, and that further investigations of Gonzales or others, and the revelations of further misdeeds that would have followed, would do more harm than good. Number 6 on our list is another infamous former White House counsel, John Wesley Dean III, who served as White House counsel to President Richard Nixon from 1970 to 1973. Of course, John Dean is known to many as the star witness against Nixon and his aides who testified before Congress as to their involvement in the Watergate break-ins that took place in Washington, D.C. in 1972 and resulting efforts to cover it up. I was born in 1972, and it was a very long time ago, 51 years to be exact, so anyone who is younger than me might not know that much about Watergate or John Dean, except that it was what caused the scandal that caused President Nixon to resign, and of course, the reason scandals are often referred to as a gate. As lawyers, however, all of us should be very interested in Watergate, despite the passage of so many years, because it was the quintessential lawyer's scandal. All in, a total of 6 lawyers were convicted of crimes arising from the attempted cover-up, and one lawyer, Nixon himself, who was a practicing lawyer before he gave up law for politics, was forced to resign the office of President of the United States, the only time that has happened in our nation's history. Now, lawyers get convicted of crimes all the time, but these were not just any lawyers. They were some of the best and brightest legal minds of their generation, or at least they held positions ordinarily reserved for the best and brightest lawyers in the land. Although we did not have room on our list to list any of them, all of them individually, I think they deserve to be named and shamed here. They were John N. Mitchell, former Attorney General of the United States, Charles W. Colson, former Special Counsel to the President, Robert C. Mardian, an Assistant Attorney General, Kenneth W. Parkinson, a lawyer who worked at the Committee to Re-elect the President, known by its acronym CREEP, G. Gordon Liddy, another lawyer at CREEP, and of course John Dean, who was White House counsel. It is amazing to me that so many distinguished lawyers were convicted or pled guilty to crimes including conspiracy, obstruction of justice, and perjury. Could all of these guys have been absent the day they taught ethics at law school? Ironically, were it not for Dean's decision to testify against them, a decision Dean made completely out of self-interest to save his own skin after his attempts to get Nixon to grant him immunity failed, the fact that Nixon had secretly recorded Oval Office conversations that supported Dean's testimony, many of these lawyers might have gotten away with it. When you are tempted to fault Bill Clinton for thinking he was above the law and the ethics rules when he lied under oath about his affair with Monica Lewinsky, his conduct pales in comparison to what this group of lawyers, including President Nixon himself, did and then tried to cover it up as part of the original Watergate. To make a long story short, Mitchell and G. Gordon Liddy hatched a plan to break into the offices of the Democratic National Committee to plant recording devices and to photograph documents. Nixon's senior advisors, including H.R. Haldeman, Nixon's chief of staff, and Dean, authorized the break-ins, and according to Dean, Nixon was aware of their plans and approved them indirectly through his chief domestic advisor, John Ehrlichman. According to Haldeman, Dean was appointed by Nixon to take the lead in coordinating the cover-up, a charge that Dean denied. After one successful break-in, the second attempt resulted in the burglars being caught in the act on June 17, 1972, which led to the conspiracy slowly unraveling over the next year. If you believe Haldeman's account, Dean was, quote, the master manipulator of the cover-up, end quote, who actively engaged in the conspiracy right up to the point that he realized everyone was going to get caught, and at which point he decided to run to prosecutors, hoping to cut a deal for himself and avoid federal prison, which he did. For example, before he went to the feds, Dean took custody of evidence and money from the White House safe of E. Howard Hunt, who had been supervising the Watergate burglaries, and later destroyed some evidence before it could be found by investigators. Of course, destruction of evidence is not only a crime, obstruction of justice, it is also an ethical violation, most notably a violation of ABA Model Rule 8.4, which in Virginia, where Dean was licensed, prohibits lawyers from committing a criminal or deliberately wrongful act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness to practice law, or from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, which reflects adversely on the lawyer's fitness to practice law. Like many other lawyers on our list, Dean was automatically disbarred in Virginia because he pled guilty to a felony involving moral turpitude per se, here obstruction of justice. So there was no need to analyze his conduct under Model Rule 8.4 and then disbarred in the District of Columbia, where he also had been admitted in an act of reciprocal discipline, the standards for which we discussed extensively in Part 1 of this program in case you didn't see it and are curious. But even if Dean hadn't pled guilty to a felony, the Virginia State Bar would have had its pick of disbarable offenses. One of them is Virginia Professional Guidelines Rule 1.7, which states that, quote, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest, end quote. Dean had several conflicts of interest with his client, President Nixon, but that did not stop him from continuing to represent Nixon throughout the unraveling of the Watergate cover-up. For example, shortly before Dean went to the feds, he asked President Nixon to grant him immunity for any crimes he may have committed while serving as White House counsel. You can't ask your client to give you immunity while still acting as his lawyer because you are, of course, very interested in whether or not he will grant you that immunity. Dean also continued to work as White House counsel and continued to assist Nixon and the White House in their efforts to cover up the Watergate scandal after Dean had hired his own attorney and started cooperating with Senate investigators. Again, you can't be informing on your client at the same time you are continuing to represent that client. I guess Dean did all of this because he thought Nixon was setting him up as a scapegoat to take the blame for the cover-up, but the ethics rules don't make any exceptions for duties to clients who you may or may no longer like or who are trying to put you in prison. Clearly, Dean would have been disbarred for any number of misdeeds arising from his role in the Watergate scandal. So what happened to Dean after he was convicted and disbarred? He was sentenced to 1 to 4 years in a minimum security prison, but ended up serving only 4 months in special safe house arrangements, typically reserved for mafia informants. Most others who were convicted or pled guilty were sentenced to very long prison terms, including Liddy, who served 4 years in prison. After Dean got out of the safe house, he taught a legal ethics CLE focusing on a lawyer's obligations when a client engages in a crime. To his credit, here is how Dean described the unique perspective he would bring to teaching legal ethics. Quote, I helped write the book of what not to do, so I'm hopeful that people can learn from that and not make the same mistakes that I did, end quote. Mr. Dean was convicted and disbarred, and even if he can still give CLE presentations on legal ethics, I don't think anyone here would trade places with him. Coming in at number 5 on our Dirty Dozen list is Roy Cohn, who is likely to be the most unethical lawyer you've never heard of. Cohn was disbarred by the New York State Appellate Division in 1986, 1 month before he died of complications from AIDS. Cohn was disbarred based on 4 specific cases involving numerous acts of misconduct, which we will discuss later. But first, we need to spend some time telling the story of Roy Cohn, who led an amazingly colorful life in which he crossed paths with many famous public figures, ranging from Joseph McCarthy to Bobby Kennedy to John Gotti and Donald Trump. Roy Cohn first gained notoriety as a prosecutor in the 1951 espionage trial of Julius and Ethel Rosenberg. Cohn's direct examination of Ethel's brother, David Greenglass, produced testimony that was key to their conviction and eventual execution. As it turned out, Greenglass later recanted his testimony, saying that he lied at the trial to protect himself and his wife, and that he was encouraged by the prosecution to do so. Cohn was never charged with suborning perjury or any other misconduct in that case, and in the climate of 1950s anti-communist hysteria, it is highly unlikely he would have been charged even if the allegations had been true. Indeed, Cohn was so proud of the result in that case that he also bragged that he personally convinced Judge Irving Kaufman to impose the death penalty on the Rosenbergs, intimating that he had done so through what would have been improper ex parte discussions. As egregious as all of this must sound, procuring false testimony to secure the conviction and eventual execution of 2 presumably innocent people, Roy Cohn was just getting started. For the record, whether the Rosenbergs were guilty of spying or not is still a matter of debate. On the one hand, we have allegations of prosecutorial misconduct and that the trial court was aware of an anti-communist witch hunt, and on the other, there was testimony in 2008 from a co-conspirator in the case, who served 18 years in prison, who said that Julius in fact had spied for the Soviets, but that Ethel had not. Whatever you believe about the Rosenbergs, Roy Cohn proved from his earliest years as a lawyer that he was not someone you wanted to mess with, a reputation he cultivated and relished over his nearly 40-year career in the law. Having impressed J. Edgar Hoover with his work on the Rosenberg case, Cohn was hired by Hoover's friend, Senator Joseph McCarthy, as his chief counsel, choosing him over Bobby Kennedy, with whom Cohn would have an ongoing feud that lasted for decades, reportedly in order to avoid accusations of an anti-Semitic motivation for the McCarthy hearings because Cohn was Jewish. In fact, during one tense set of hearings, Cohn and Kennedy got into a shoving match that nearly ended in a fistfight. As McCarthy's chief counsel, Cohn was directly responsible for many of the key prosecutions that made up McCarthy's war on communism. One notable episode in that campaign became known as the Lavender Scare, in which McCarthy and Cohn alleged that closeted homosexuals in the U.S. government were passing secrets to the Russians in return for keeping their sexuality a secret. The Lavender Scare was so successful that it convinced President Eisenhower that employing homosexuals was a threat to national security, and in April 1953, he signed an executive order banning homosexuals from obtaining jobs in the federal government. Clearly not our finest hour, and Roy Cohn played a key role in having gays banned for a time from government service. The interesting twist here is that for much of his life, Cohn was suspected of being gay himself, having never married and having had several close male friends at various times in his life, including Studio 54 owner Steve Rubell and famed artist Andy Warhol. Of course, the fact that Cohn died from complications from AIDS in 1986, when the AIDS endemic was affecting primarily gay men, also fueled speculation that Cohn was gay. This is certainly the spin that Hollywood put on Roy Cohn's life, most famously by Tony Kushner's play Angels in America, where Cohn is portrayed as a closeted, power-hungry hypocrite who is haunted by the ghost of Ethel Rosenberg as he lies dying of AIDS, a disease he insisted until his death be called liver cancer. After Joseph McCarthy fell out of favor, Cohn moved back to New York City to start his legal practice. During his long career, he represented a who's who of New York personalities, including Mr. Trump, mafia figures Tony Salerno, Carmine Galante, and John Gotti, Studio 54 owners Steve Rubell and Ian Schrager, and somewhat surprisingly, the Roman Catholic Diocese of New York, and somewhat less surprisingly, George Steinbrenner and the New York Yankees. One of the Trump cases is too good not to recount here. In 1973, Mr. Trump was accused by the DOJ of violations of the Fair Housing Act. The DOJ alleged that in 39 buildings managed by Mr. Trump, his corporation quoted different rental terms and conditions to African Americans and made false no-vacancy statements to them for apartments it managed in Brooklyn, Queens, and Staten Island. Representing Mr. Trump, Cohn filed a countersuit against the government for $100 million, asserting that the charges were irresponsible and baseless. Cohn and Trump lost their countersuit, no surprise there, and settled the case with the DOJ on terms that were not disclosed. Even though Cohn lost this case for Trump, Trump liked Cohn's aggressive style of lawyering and used him repeatedly for future cases. As Trump would later explain, quote, "The mere sending of a letter from Roy Cohn has saved us a lot of money. When people know that Roy is involved, they'd rather not get involved in the lawsuits and everything else that's involved," end quote. Here's how Cohn put it, quote, "It's fair to say that in an adversary situation, I've got one role, to win for my client. Law is an adversary profession. But within the bounds which are permitted, most lawyers are Casper milquetoasts. They don't realize they are in a fight. To them, a lawsuit is nothing more than going to court, then going to lunch with your adversary. To me, it's serious business," end quote. I think you could say that Donald Trump and Roy Cohn are kindred spirits, to put it mildly. Oddly for a lawyer, Cohn became most known for cases where he was a defendant instead of cases where he represented the defendant. In the 1960s, Cohn was tried and acquitted 3 separate times in federal court on charges ranging from conspiracy to bribery to fraud. Each of these cases was brought by then U.S. Attorney Robert Morgenthau with the support of then Attorney General of the United States, Bobby Kennedy, Cohn's old rival from his McCarthy Commission days. The first case, which charged Cohn with obstruction of justice and perjury in connection with his representation of defendants in a stock swindle case, ended in a mistrial when one juror's father died. At the retrial, Cohn was acquitted. In the second case, Cohn was charged with bribery, conspiracy, extortion, and blackmail for allegedly bribing a city appraiser to help his client secure a higher award in a condemnation trial. During that trial, Cohn's lawyer was felled by a heart attack just prior to closing arguments, which allowed Cohn to step in and give his own closing statement without ever having had to testify under oath at the trial. Because this turn of events resulted in such a big advantage for Cohn at the trial, there was speculation that his lawyer feigned the heart attack so Cohn could speak directly to the jury in closing argument. In the third case, Cohn was accused of bribery, conspiracy, and filing false reports with the SEC, based largely on testimony of former business associates who testified against Cohn in return for guilty pleas and no jail time. Once again, Cohn was acquitted. As one former prosecutor who believed Cohn should be put behind bars put it, quote, "He's the only person I've ever known as a prosecutor who enjoyed being indicted. He enjoys the limelight," end quote. Cohn was not quite as lucky in his dealings with the IRS, which audited his tax returns for more than 20 years in a row and collected more than $300,000 in back taxes. At one point, the IRS had liens against Cohn totaling more than $3 million, but it seems that Cohn once again had the last laugh. To avoid paying his tax liens, Cohn took a low salary of $100,000 a year from his law firm, which compensated him further by giving him a rent-free apartment, paying part of the rent on his Greenwich home, supplying him with a chauffeur-driven Rolls-Royce and other fine cars, and paying his bills at fancy restaurants such as Le Cirque and 21. These expenses were said to run in excess of $1 million a year. As a friend put it, Cohn's absolute goal was to die completely broke and owing millions to the IRS. He succeeded in that. This brings us to how Roy Cohn finally came to lose his law license in the waning months of his long and colorful life. The New York State Appellate Division that disbarred him summed it up pretty succinctly as follows, quote, "Avoiding repayment of a financial obligation to a client, violating an escrow order, procuring execution of a testamentary instrument under circumstances of misrepresentation, and omitting judicial findings of misconduct from a bar admission application are all serious charges which reflect adversely on the legal profession and the reputation of those who practice before the bar. One need not be a lawyer to recognize the impropriety of such conduct. For an attorney practicing for nearly 40 years in this state, such misconduct is inexcusable, notwithstanding an impressive array of character witnesses who testified in mitigation," end quote. In short, when the time came to disbar Roy Cohn, the New York State Appellate Division had a pretty long list of violations to choose from, reflecting his very colorful career as a lawyer. The most interesting charge was the one about procuring execution of a testamentary instrument under circumstances of misrepresentation. What happened here is that Cohn flew to Florida in order to obtain the signature of Louis Rosenstiel, a multimillionaire philanthropist, on a codicil that would have appointed Cohn and Cohn's clients, Kathy Finkelstein and her husband James Finkelstein, as executors of Rosensteel's will. Well, that doesn't sound so bad, you might say. Cohn just dropped in at Rosensteel at his home while he was finishing up a game of tennis, explained the need for the change, and obtained his consent, right? Not exactly. Not only was Rosensteel at the hospital, but the appellate division described his condition as follows, quote, "At the time Cohn entered the hospital, Rosensteel was already in poor health with a history of diabetes, high blood pressure, prostate cancer, and assorted heart and blood disorders. His eyesight was poor, with practically no vision in one eye and limited vision in the other, and he could walk only with assistance," end quote. But wait a second, you say, Rosensteel signed the codicil, right? If he was able to sign his name on the document, he must have understood what was going on. Here's the signature that Cohn obtained on the codicil. As the appellate division put it, quote, "The purported testamentary signature consists of a number of squiggly lines, which in no way resembles any letters of the alphabet," end quote. The court also noted that, quote, "An expert document examiner testified at the probate proceedings that he could find no legible characters of any nature in this purported signature, and that he had never seen anything like it in all his years of experience," end quote. So Cohn basically forged something resembling a signature from someone who was clearly incapable of understanding what was going on, much less signing the document. Cohn engaged in some related shenanigans and misrepresentations involving hospital personnel who questioned him and tried to stop him from obtaining Rosensteel's signature. Then Cohn tried to use the codicil to alter the terms of Rosensteel's will, an effort that the Florida probate court soundly rejected. Why was Cohn doing this? According to the appellate division, Cohn's conduct was particularly reprehensible in light of the fact that this codicil was designed to give him, among other things, a personal interest as co-executor of the testator's sizable estate. The court also nailed Cohn for having given untruthful and misleading testimony in his disciplinary proceeding about the events that took place in the hospital, which testimony, as well as the underlying conduct, the court said was evidence of highly unprofessional conduct for an attorney at law. The court did say which specific ethics rules Cohn violated in connection with the Rosensteel codicil, but I think you can safely say it was most of them. The appellate division also disbarred Cohn for conduct in connection with an escrow account that his firm was managing for the benefit of creditors of one of his clients. A lot happened here, but the headline is that Cohn allowed several valuable assets to be substituted for bonds that ended up being worthless, including a valuable yacht that ended up being destroyed. Incredibly, and you won't get this from reading the court's opinion, but you can find references to it in press articles, there is speculation that Cohn arranged for the yacht to sink in order to collect on an insurance policy for his client, but that resulted in the death of a young man. No one was able to prove that Cohn sank the yacht or caused this man's death, but no one said it couldn't have gone down that way either. For all you young lawyers out there, insurance fraud and manslaughter will definitely get you disbarred, even faster than commingling client funds or failing to fulfill your CLE obligations. And with that, the infamous Roy Cohn was disbarred on June 23, 1986. Had he not passed away about a month later, I'm confident he would have appealed and maybe even filed a $100 million counterclaim. In the realm of it's a very small legal world, who represented Roy Cohn before the appellate division in his disbarment case? None other than Michael B. Mukasey, who was then in private practice with Patterson, Webb, Belknap, Webb, and Tyler. This was probably one of Judge Mukasey's last cases before he was appointed to the federal bench in November 1987, and I'm sure it was one of his most memorable. Next up is the legendary Clarence Darrow, who is also number 4 of the 12 most unethical lawyers in U.S. history. While the name Clarence Darrow is often synonymous with great lawyer, as in, he's good, but he's no Clarence Darrow, given his flexible ethics, his name should be synonymous with great liar. Does this surprise you, or had you heard that the great Clarence Darrow had a dark side? Unless you should think that this is a close call in terms of possible claims of unethical conduct by Darrow, or some squishy what kind of lawyer do you want to be argument I'm making against him when I can't prove actual ethical violations. Here is a summary of Darrow's unethical conduct in just one of his famous cases, the 1911 trial of the McNamara brothers, who were accused of bombing the LA Times building that killed 20 people. Quote, 2 jurors bribed, 2 witnesses paid to get out of the country, 2 witnesses paid to testify falsely, a corrupt scheme to destroy certain physical evidence in the possession of state authorities, the corruption of practically every employee of the Los Angeles County Jail who came in contact with the McNamaras, complicity in a scheme of Ditmo, Johnson, and others to get Mrs. Kaplan out of the state, she being the wife of one of those indicted for the Times murder and still being secreted, the hiring of George Beam, uncle of Ordie Manigault, to induce the latter to repudiate his confession on the personal guarantee of Darrow that Manigault would be made a free man, and other minor irregularities almost too numerous to mention." End quote. Wow, that's quite a list, and it all happened in a single case. This sort of puts the O.J. trial into perspective. Maybe it wasn't the most unethical display of lawyering in history after all. As we will see, although Darrow denied these allegations, the evidence against him was so compelling that he had to fall back on his second defense, which was, "Even if I did it, I was fighting fire with fire as the prosecutors were engaging in the same misconduct of which I stand accused." Of course, the other side did it first is never a defense to unethical conduct. But in fairness to Darrow, the McNamara trial was a nasty affair during a particularly nasty period in this country when organized labor was locked in a life and death struggle with industry over their right to unionize. There were many strikes, bombings, riots, and deaths on both sides during this period of unrest, so it's not entirely surprising that the McNamara case was litigated with bare knuckles by both sides. Just how bare those knuckles were, however, I think will surprise you. That said, none of this justifies what Darrow did in his efforts to win that case, as we shall see in a moment. The McNamara case was the trial of the century of its day, where John and James McNamara were accused of dynamiting the Los Angeles Times building on October 1st, 1910, during the bitter struggle over open or non-union shops that took place in Southern California during this period. In those days, the LA Times was a fierce opponent of organized labor and thus a target for unionists like the McNamara brothers. The bomb detonated prematurely when the Times was still occupied by employees, and although it did not bring down the building, it ignited a fire that killed 20 people. The American Federation of Labor donated money to fund the defense of the McNamaras and arranged for Darrow to be hired as lead counsel. So what evidence did they have against Darrow on the charges of bribing jurors? Well, it was pretty strong. The juror reported the offer to police, who set up a sting and observed the defense team's chief investigator, Burt Franklin, delivering $4,000 to the juror 2 blocks away from Darrow's office. After making payment, Franklin walked 1 block in the direction of Darrow's office before being arrested right in front of Darrow himself, who had just walked to that very intersection after receiving a phone call in his office. It sounds pretty damning, and it was. So damning, in fact, that in his closing argument in the second trial, Darrow had to fall back on arguing that if he did it, he was just fighting fire with fire. Here's part of Darrow's closing argument. Quote, "Suppose you thought that I was guilty. Suppose you thought so. Would you dare to say by your verdict that scoundrels like the district attorney should be saved from their own sins by charging those sins to someone else? Now, gentlemen, I'm going to be honest with you in this matter. The McNamara case was a hard fight. Here was the district attorney with his sleuths. Here was Burns with his hounds. Here was the Erectors Association with its gold. A man could not stir out of his home or out of his office without being attacked by these men ready to commit all sorts of deeds. Besides, they had the grand jury, we didn't. They had the police force, we didn't. They had organized government, we didn't. We had to work fast and hard. We had to work the best we could, and I would like to compare notes with them," end quote. That trial ended in a hung jury, after which Darrow struck a deal with the prosecutor not to retry him if he agreed never to practice law in California again. This turned out not to be a huge problem for Darrow, who took the train back east where he handled famous cases in Chicago, the Leopold and Loeb case, and in Tennessee, the Scopes Monkey trial, as part of his long career. So why did the jury in his bribery trial accept Darrow's argument that he shouldn't be found guilty even if he bribed the juror? First of all, the jury probably just wanted to get out of there. Darrow was famous for giving some of the longest closing arguments of any lawyer in history. In the Leopold and Loeb case, Darrow's closing lasted 12 hours, and in another of his famous trials, he spoke to the jury for 7 hours. Can you believe that? I'm sure any juror would vote however it was necessary in order to get Darrow to stop talking to them. Second, the conduct of the prosecutors in the McNamara case was pretty egregious, including bribing witnesses, having ex parte communications with judges, kidnapping defendants, and engaging in spying and eavesdropping on defense lawyers. Jerry Ullman chronicles much of this misconduct by prosecutors in his excellent article, and he also explains how all of this could have happened in the United States, where we generally think the rule of law prevails and that lawyers follow the rules, except for a few bad apples that we choose to shame in our program here today. Big picture, the fight between unionists and industry in those days was no less than a fight for the survival of the nation. It was socialism against capitalism, poor against rich, immigrants against the establishment, young against old, that caused everyone to push the bounds of the law to deny victory to the other side. In fact, Darrow was fairly described as a zealot for the unionist cause, and it's clear that most of what he did that was illegal and unethical, he did for the larger cause of unions rather than solely out of a desire to win the case for his clients. Here is Darrow in his own words, quote, With the land and possessions of America rapidly passing into the hands of a favored few, with great corporations taking the place of individual effort, with the small shops going down before the great factories and department stores, with thousands of men and women in idleness and want, with wages constantly tending to a lower level, with the number of men and women and children rapidly increasing in factory and store, with the sight of thousands of children forced into involuntary slavery at the tender age that should find them at home or in school, with courts sending men to jail without trial for daring to refuse to work, with bribery and corruption openly charged, constantly reiterated by the press and universally believed, and above all and more than all, with the knowledge that the servants of the people elected to correct abuses are bought and sold in legislative halls at the bidding of corporations and individuals, with all these notorious evils sapping the foundations of popular government and destroying personal liberty, some rude awakening must come. And if it shall come in the lightning and tornado of civil war, the same as 40 years ago, when you then look abroad over the ruin and desolation, remember the long years in which the storm was rising, and do not blame the thunderbolt." End quote. If you were wondering how Darrow could speak to a jury for 12 hours straight, I think the verbosity of that quote should give you some idea. Summing it up, Darrow clearly thought that the ends of fighting for labor justified the illegal and unethical means he employed in the McNamara case. Can the ends ever justify the means with regard to legal ethics issues? Can a lawyer ever serve larger societal goals at the expense of his client's interests? Of course, the answer to both questions is clearly no. The legal ethics rules are just that, rules, that every lawyer must follow no matter what ends he or she is pursuing. On the second point, Darrow has the argument backwards. A lawyer is ethically obligated to pursue his client's interests without regard to his own interests or the interests of society as a whole. See, for example, Model Rule 1.7, which prohibits a lawyer from representing a client if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. While a lawyer may, under Model Rule 2.2, in the course of representing a client, refer not only to law but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation, nothing authorizes a lawyer to allow those factors, including the lawyer's own personal beliefs, to supplant the client's interests as the lawyer's sole objective in the representation. You might say that representing unionists accused of bombing an anti-union newspaper serves both the interests of the clients and the union, and the fact is that both interests can, in fact, diverge in the McNamara case. When Darrow's attempt to bribe the juror was exposed, Darrow lost much of his leverage in the negotiations with the prosecutors over a possible plea deal, and the deal he got for the McNamara brothers, while it spared them the death penalty, resulted in a life sentence for James and 15 years for John. Even then, many unionists accused Darrow of having sold out the movement by making the plea deal rather than taking the case to trial. Once again, Jerry Ullman sums it up quite nicely in the following passage from his article on Clarence Darrow. Quote, "This reflection on the ethics of Clarence Darrow has led me to an unanticipated conclusion. My personal hero, the man who inspired my own ambition to become a lawyer, turns out to have not just been unethical, but a lousy lawyer to boot. By fighting fire with fire, he ended up not only burning himself, but he seriously damaged the cause of labor as well. If Clarence Darrow's career had ended in 1911, he would surely be consigned to the hell of ignominy. But Darrow lived for another 26 years, and during that period, he pursued a very different direction in his legal career. He never represented the cause of labor again, but the causes he took up were just as important. He truly redeemed himself and gained his place as an inspirational role model for future generations of lawyers. When we emulate the ideals of Clarence Darrow, it should not be by fighting fire with fire. It should be by directing a steady stream of water on the fires that still smolder today, replicating the injustices of a century ago. The well-meaning men of zeal who are ready to burn up our constitutional liberties in order to enhance our security are with us today, just as they were 100 years ago. The way to defeat them is by the kind of advocacy that Darrow demonstrated in the courtrooms of Dayton, Tennessee, and Chicago, Illinois, advocacy that turned the hearts and minds of an entire generation, not by fighting fire with fire, but by fighting ignorance and hate with wisdom and love." End quote. With that, we've reached the end of part 2 of the Dirty Dozen, the 12 most unethical lawyers in the history of the U.S. I hope you enjoyed it, and thanks for watching.